Hello, my name is Curtis Morrison. I'm an immigration attorney in Southern California. I practice law in California and Washington, D.C. This video is about a multi-participant lawsuit called the Reuniting Families lawsuit that we will bring soon. A little background so you understand where we are coming from with this lawsuit. On April 22nd, 2020, Trump issued a ban, PP 10014, and then he extended it on June 22nd, 2020 until the end of the year, and that was called the labor ban. What he's trying to do is like keep people from coming to the U.S. So on October the 1st, 2020, in a lawsuit in San Francisco called NAM versus U.S. Department of Homeland Security, Judge White ordered that these bans would not apply to corporate plaintiffs and these organizations and their members that are before the court. They use non-immigrant labor like H-1Bs, and the judge said it doesn't apply to them. So the objective of the Reuniting Families lawsuit that we will file is we seek to achieve the same result achieved by NAM versus U.S. Department of Homeland Security, but for family-based immigrants. That's the plaintiffs that we want. Specifically, our named plaintiffs should not be subject to the entry restrictions of 10014 extended by 10052, and nor should those entry restrictions be used as a ban on visa issuance. They should still be issuing the visas. We will argue families should be allowed to be reunited as soon as possible and not have to wait till the end of the year or the end of Trump's next extension, because who knows, he may extend the ban again, right? So the attorneys bringing the case, Rafael Urena, my colleague, and also me, Curtis Lee Morrison, and we will bring it through the law office of Rafael Urena. We will have other attorneys support us too. The case will be filed in the District Court for the Northern District of California. That's in San Francisco. The defendants will be Donald Trump, the president, and Michael Pompeo, the Secretary of State. The deadline to participate is October 9th, 2020. It's coming very fast. You can't participate after that, okay? We will file the lawsuit on October 14th, 2020. To participate in the Reuniting Families lawsuit, clients must have a family-based petition approved by USCIS in one of the following categories. Okay, the first one, F1, that's unmarried sons and daughters, 21 years of age and older, of U.S. citizens. F2A, spouses and children of permanent residents. F2B, unmarried sons and daughters, 21 years of age or older, of permanent residents. F3, married sons and daughters of U.S. citizens. F4, brothers and sisters of adult U.S. citizens. And then finally, IR5, that's a parent of a U.S. citizen who is at least 21 years old. So the client must be awaiting the issuance of a family-based visa that is currently held up by one of these two proclamations, but 10014 extended by 10052. It is not necessary that the client has already had an interview. The clients who have been issued a visa but have not been able to enter the U.S. because of this ban, they can also participate, okay? And then finally, the client's Form I-130 petition must have already been approved by USCIS. So if it's still in process, this ban is not the problem, so we don't want you on the lawsuit. The upfront fee, as far as the cost of the lawsuit, will be $500 to start the representation, and then $500 upon the primary beneficiary's arrival in the United States. And then additional $500 for each derivative beneficiary payable when they arrive in the United States. For example, for two visa applicants from the same petitioner, the fee would be $500 now and $1,000 upon their entry in the United States, and so on. So if there's no entry in the United States, the final payment is waived, okay? So if we fail, we don't need to get paid again at the end, okay? We only get that reward if we do the job. So disclosures. The client understands that there are no guarantees as to the outcome of litigation. 2, the client understands that the government will never disclose when a visa is approved or a waiver adjudicated due to the efforts of attorneys. So if a client's visa is issued prior to the filing of the lawsuit and you get to come to the U.S., then no fees will be due. to the attorneys. But if the visa is issued after we file that lawsuit, or you come to the U.S. after we file that lawsuit, then the fees will be due. And there's no way around that. You can send me an email and say, do I get an exception? No. If we're doing the work, we're going to get paid. Okay, so sometimes this means that clients have to pay who gets visas quick, and sometimes it means clients have to pay who have to wait longer for visas. That's just the way it works. The client also understands that participating in a lawsuit means public disclosure of private facts, okay? For example, a Google search might not turn up your name now if you've not lived a life online. It will after we file the lawsuit, okay, because your name will be listed in the lawsuit. There will be multiple participants in the lawsuit, and so attorneys will prioritize the interest of the whole. This lawsuit will just not be about you and your claims. It'll be about everybody's and what's in common to everybody. I want to say that attorneys do not have professional liability insurance. California makes me tell you that. So if all that sounds okay, and your family is interested in participating and benefiting from the Reuniting Families lawsuit, then we will send you an onboarding email. After you complete the form, complete the interest form, we will send you an onboarding email with a proposed retainer agreement. If that looks okay, return that to me, and then we will send you an invoice. After you pay the invoice, we will send you a questionnaire to make sure we have all the information we need for the lawsuit. So that's, in a nutshell, what the Reuniting Families lawsuit is about. Thanks for your time in viewing this video, and good luck to you no matter what you decide to do. Thanks a lot.